On the docket, I think the state has an announcement in this case.
State,
Tidwell.
Yes.
Tidwell,
The state-
Tidwell.
The
Yep,
state
go
is
ahead.
dismissing is announcing a dismissal on the violation of probation. Probation will run as normal.
Okay, so what, we have to, you're just doing a dismissal, do we have to take any action here today? Any
No, Your Honor.
reinstate?
No, Your Honor. Her probation will continue
Okay.
as it was.
And
Very
it'll be
good.
my responsibility to advise her to contact probation.
Okay, very good. Thank you,
Thank
Mr.
you.
Gates.
That's
Have a
all I
good
have.
day. Stay warm. Mr. Shaw.
Morning, Judge.
Good morning.
Tim Shaw, I have Jaden Bartley on
Correct.
the court's docket today. I think the state had indicated you wanted to put this on for a full-blown evidentiary hearing.
Yes, Your Honor. We almost said that with Judge Clark.
Okay. Okay,
And Mr. Bartley is en route from Tallahassee, so I'm going to stop him and tell him to turn around and go.
okay. Okay, so we need to take any action?
Just set it, oh, well, I don't know, are
Thank
you
you.
setting dates, or are we waiting?
Well,
for it?
that's the thing. I mean, normally what I would say is talk to Miss Eileen and set an afternoon miscellaneous hearing, but I don't know if we have any slots left. See, I don't know whether you'll have to, if we have a slot left between now and January, but if it's not until then, it'll have to be, I think they're gonna do the same type of coordination, I'm assuming, with Judge Clark.
Your Honor, just in abundance of caution, it looks like Judge Clark's miscellaneous date in January is the 21st. If we want to leave it set on that date, just in case, and then we can
You're
set.
talking about in the morning,
Yes, sir.
just like it's a status?
Yes, just to make sure we have the afternoon hearing set with Judge Clark.
Y'all have announced you need an evidentiary, call our office and get an evidentiary set.
Yes, sir.
We'll do that.
I mean, I don't think you have to,
That's fine. However the court wants to handle it.
yeah, I don't think we have to put it on.
Thank you, Judge.
Okay. So I'm just gonna put it in the minutes, so it'll just say TBD, to be determined, date, evidentiary being requested.
Thank you, Judge.
Okay. Very good. Okay, so we'll just start at the top and kind of go through these. Justin Hammett, this is the other Mr. Gates.
Yes, Your Honor. Mr. Hammond is actually not here yet. I talked with him yesterday, so he should be en route to be passed in.
Okay. See?
We did skip over one, Your Honor. Daniel Guity, Guity.
Okay, I don't have that on mine. What number is that?
Your Honor, he's before the court in 23 CF 2023.
Okay. Yeah, it's not on my docket, it's 22. So we didn't skip over it. Daniel Guidi.
Yes, Your Honor.
Okay, go ahead.
I think the state's got an announcement in this, Your Honor.
Yes, Your Honor. The state is announcing a dismissal on the violation of probation only. The probation will continue as it was.
Very good. I don't think we need to take any action with that. Just be in touch with your probation officer, okay? Okay, thank you very much.
Your Honor, can I call one other out of order real quick?
Sure.
It's going to be Luke Kimsey. Mr. Kimsey's in the back. He's before the court, 23 CF 1671.
Okay, got it?
Your Honor, the sole basis of the VOP was dismissed last week, so I think the state has an announcement in this one.
Yes, Your Honor. The state is announcing a dismissal of the violation of probation, original terms and conditions to continue.
Very good. Okay, make sure and be in touch with your probation officer.
And if I can, Your Honor, I know I wanted to let probation know.
Probation?
Zeta, this Ross, he's with JCS. Yeah.
Okay.
This Ross, for the record, Mr. Kimsey had to do, was it 30 days jail or 10 days jail? 10 days jail.
Yes, sir.
And based upon the violation of probation, he has served the 10 days jail at this point, now that it's been dismissed. So the notes indicate that his probation should be modified to administrative probation upon the completion of that jail. So if you could just make a note, it's now administrative probation moving forward. Yeah.
All right.
Thank you, Your Honor.
Thank you. Okay, so we'll just start from the top and see if there are, why don't we do the no attorneys and see if anybody's here. Stephen Arnett? Okay, this is case number 23 CF 1878. Okay, Mr. Arnett,
Your Honor, I do have my public defender here, Stephen Medina. He's out in the
well, he's
hall.
not been appointed yet. That's what I was going to do first, is appoint.
Oh,
Okay, so there's a violation of probation, that's like a new charge.
yes, sir.
So you've got to have an attorney appointed there. It'll be Mr. Medina again, but I have to appoint. So I was going to ask you, do you want to have an attorney? Because you're listed as not having an attorney.
Yes, sir.
So you want the public defender appointed. So what I'm going to do is I'm going to enter a denial. This is like an arraignment hearing.
Yes,
So I'm going to enter a denial. We'll set it on the next miscellaneous docket, and then you can meet up with Mr. Medina,
Yes, sir.
okay? So, because you've got his number and whatnot. What's our next date, Madam Clerk? Is it for miscellaneous?
December 17th or January 21st.
Okay, so it'll be January 21st
Yes, sir.
at 9 a.m.
Yes, sir.
But meet up with Mr. Medina in the interim and go over and figure out what's going on with it, okay? Okay, thank you. Is Bryce Boyette here? Bryce Boyette. State?
Your Honor, the state is going to be requesting a KPS for Mr. Boyette.
Was there proper service?
I was just looking at that, Your Honor.
Welcome back.
Thank you, Judge.
You survived? Jeff?
Yeah, Ponte Vedra is a fun part of Florida.
Yes, it is.
Yes, $575 if you want to play. I did not play it.
We'll get yours next week, Heather. We'll get, hold on a second.
That is in his bond when he sent it.
Okay. So court will issue a no bond KPS.
Thank you, Judge.
Mr. Cadillac, you want to do yours? Okay. Let me-
You could have called me. Hello.
SRA.
Lisa?
Morning, Mr. Cadillac.
No, I'm saying you could have just called me. You could have saved yourself a whole hearing. I'll do something less. I can do 2,500 per count. With Procedural services and GPS monitor around this whole area. No, it's about. Well, okay, maybe you shouldn't be persuasive, but
Judge, I think we have an agreement on the motion to reduce bond for settlement at $2,500 per count for a total of.
Your Honor, it's currently charged with 30 counts of possession of child sexual abuse material, so it'd be 2,500 per count. He's also charged with transmission of harmful material, 1 count, so that would be another 2,500, and unlawful use of a two-way device, another 2,500, cash and professional. What we are requesting, Your Honor, to safeguard the community.
What's the total on that
Oh,
then?
sure, you're gonna ask me. It should be 30,000, I believe, Your Honor.
Okay.
Your Honor, the key thing, what we really are interested in this case is for the protection of the community and children is going to be ask that Mr. Esrae be on pretrial services, have a GPS monitor, allowed no contact with any minors, and also no access to electronic devices or access to internet or social media.
I have an order, sir.
Okay.
Can I present it?
You understand all that?
Don't think the order has those conditions, so though.
No.
It just says granted or denied. think he needs conditions.
I want the conditions
Want
on there.
conditions, Judge?
Yes.
Yeah, you can bring them back. You don't have to do it now.
Okay.
We can get it done. But did you understand all those? You heard those conditions?
Yes, sir, I heard.
Okay, those are absolute. You violate those, they'll be back and they'll pull the whole bond. Okay, so it's,
Are there any minors in the home we need to worry about, sir?
No, sir, no,
Okay, I
ma'am.
just want to make sure before we leave here today.
okay,
Thank you.
very good. Okay. Thank you, Mr. Catalan.
Thank you, Judge. That's all I have. May I be excused?
You may. Thank you.
Thank you, sir. See you later.
Just want, if you want to just shoot the copy that was made.
Yes, ma'am.
All right, and I'll get you the discovery charging document, all the kinds of. If you want to look at the images, you can have them all. If you want to look at the images, you can have them all.
Is Robert Brazil here? State?
Your Honor, I do not see Mr. Brazil here. I do see a notice that is docketed that was sent on November the 12th with this court date on it, and it does look like it was returned from Mr. Brazil. So I was just looking at the bond that was posted, Your Honor. And it does unfortunately say that he is to return TBD. So, Your Honor, I think that in this instance, the court might want to reset it and see if,
Okay, why don't we continue this till January 21st docket, and if you all can get service on him, he doesn't show, then we'll deal with it.
yes, Your Honor.
Is Cedric Hill in the courtroom? Come forward. Okay, this is case number 23 CF 600. Again, Mr. Hill, this is a VO, violation of probation. It's like a new charge. You do have the right to have an attorney. I note that you don't have an attorney. You wish to have an attorney appointed?
Yes, sir.
Okay. The court's going to appoint the public defender. I'm going to go ahead and enter a denial. That's like a not guilty plea, okay? So that you'll have a chance to meet up with your attorney. We'll come back on January 21st at 9 a.m. for the next court date. In the meantime, you can meet up with your attorney. Ms. Farkas going to be your attorney?
No, it's going to be Travis Gates, so I've got his card, and then if you could fill out this contact information for him, and you could get an app. I think they've got applications over here, fill that out for you.
The state might need to help me on this one. The first case we had with Mr. Gates was Kayla Tidwell. And as I was going through my docket, I checked off 22 CF 1536, but then later in my docket, I see another case with a no attorney on it, 21 CF 2675. Is that also dismissed?
Yes, Your Honor, that is also, the violation of probation is also dismissed in that
Okay,
case.
very good. So I just want to make sure. Okay. Very good. So those are all of our, no. Mr. Harper, you want to do yours?
Yes, Judge, if I may.
Or do we want to do any that are in court? Do you have any that are in the courtroom, any out of custody? Ms. Farkas, do you have any out of custody that we can deal with? And then we'll just ask Mr. Medina and
I do,
Mr.
Your
Gates
Honor.
the same thing?
I have one client who is out of custody. I just need her to sign the plea agreement, but other than that, we're good to go.
Okay, that's good.
So we can get that.
What's the name?
Leslie Early, E-A-R-L-Y.
Okay.
All right. If I may approach, Your Honor. I need the, okay. If I may approach.
You may. Would you announce the terms?
Yes, Your Honor. The case number is 2019-2452. There is one VOP count for a third-degree felony. There was a previous withhold of adjudication. Ms. Early will admit the VOP and maintain the withhold of adjudication, reinstate and modify probation to extend 1 year from the original termination date. She's made substantial payments to restitution, and so we're just extending it to allow her to continue to do that. So the new termination date will be December 4th, 2025. Sorry.
I didn't know you weren't done. I'm
Complete
sorry.
all the original terms, public defender fee and cost of prosecution.
That's the state's agreement, Your Honor, and the state contacted the victim about this violation of probation. The victim understands that this is the agreement between the state and the defendant.
Very good. Ms. Early, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, I see you signed the agreement, you've gone over it with your attorney. Just want to make sure you understand, you do have the right to go to a hearing on this, and you're waiving that right in order to get this resolution. It's pretty straightforward why you're doing it, but I just want to make sure you've kind of gone over, had all your legal questions answered by your attorney.
Absolutely, sir.
And you're entering this freely and voluntarily. Based upon that, the court will accept your plea. There'll be an admission of the VOP. The withhold of adjudication will continue. The court will reinstate and modify probation to extend for 1 year from the original termination date. So the new termination date will be December 4, 25. And then you have to complete all the original terms of probation, including continuing to pay restitution. Then, of course, they always hit you with the inevitable fees and costs, public defender fee and cost of prosecution. Any questions?
No, sir.
Okay, good luck.
Your Honor, I have William Davis Jr. up next, 2023 CF 155 and 2024 CF 614.
Okay.
I have the offer from the state attorney, but I have not been able to meet up with Mr. Davis to review the offer. So if we can have another cycle continuance.
So we've already entered a denial?
Yes.
Okay,
we
so
have
we'll
entered a
continue it to 121,
Thank you, Your Honor.
January 21st, 9 a.m. Anybody else, Ms. Farkas?
I believe that's all my, unless there's someone I haven't met, I believe that's all of my out-of-custody claims.
Mr. Gates, do you have any out-of-custodies?
Nothing I'm aware of right now, Your Honor.
Okay. Then I'll wait for, Mr. Medina, do you have any out-of-custody
Yes, I do,
folks?
Your Honor.
Why don't we go ahead and get those so they can
Okay.
be on their way?
Let me just, may I squeeze by, ma'am?
Oh, sorry.
Sorry, thank you. Sorry, Your Honor.
It's all right.
So let me begin with persons that are in custody, out of custody in the courtroom. Jamari Bush. Mr. Bush is, it's spelled J-H-A-M-A-R-I, Bush.
Hold on, so let me find that one.
I'm sorry,
Mr.
Judge,
Medina.
I will
That's all right.
find it.
That's all right. Give me the spelling again,
B-U-S-H, like the
Okay, Bush,
president's.
yep, okay. Jamar, got it?
And, Your Honor, Jamari L. Bush is before the court in 19 CF 1059. Can I approach with him and with the state, Your Honor?
Sure.
Okay, thank you.
Heroes Save Money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 888-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Hi, this is Alex Barthay from the UPS store in Crestview, Florida. We also have Eglin Air Force Base and Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should start letting you know that we're getting close to having parts of the country each day cut off. So go to
Bush, if we could continue this till January 21st of 2025, Your Honor.
Court will continue this till the 21st of January.
Okay, and you're going to set an appointment with me. I gave you my card, right? Okay, thank you.
Thank you. Very pleased with you. Have a good day.
Thank you, Your Honor. Your Honor, I think my other out of custody, I've notified my office to try to reach 3 people that aren't here that need to be. But I do have one from the arraignment docket this afternoon who's 4 hours early, David E. Groom from the afternoon docket. Can we go ahead and have him come up?
Sure.
Mr. Broom is before the court in 24 CF 2547 from the arraignment docket today.
Hold on a second, let me find
Sorry
it.
about that,
That's
Judge.
all right.
He's number
Okay,
6.
Got it.
David Ernest Broom Jr. He will plead not guilty, and he's going to set an appointment and meet with me. Can the clerk please tell us if he has completed his application?
I do not see an application.
So you're going to need to complete the public defender application right there before you
come back
leave
for the
court.
February pre-trial.
Right on the first floor.
Yes, sir.
So set an appointment with Karen and meet with me.
So our next hearing will be February 10th. Meet up with your attorney in the interim.
February 10. You want me to write it for
Yes,
you?
please.
2/10/25 at 9 a.m. That's court. Meantime, you meet, don't leave the courthouse without filling that in completely and turning it in on the first floor. Thank you, Your Honor.
Sure.
I'm looking for my other people, Your Honor.
Okay.
Your Honor, I understand there's somebody with a letter B that may be my client that I don't have a file for yet. Will you approach? I don't know the status of appointment of the public defender for Mr. Boyette.
This is Mr. Boyette?
Yes. I do not have a file for him. What is his?
This is I've got a no attorney, and there was a capias issue because he didn't show up. So we'll withdraw the capias. You need to be here on time. You had a pickup order out.
Right issues. I scheduled an Uber. And
Okay.
They didn't.
I'm just saying, make sure and take care of it.
Sir.
Did you have the?
Hold on. I'm gonna ask him if he wants an appointment, Mr. Medina, just hold on.
Yes.
So, Mr. Boyette, your case is 23 CF 109, it's obviously a violation, it's like a new charge. So even though you may have an attorney in the other case, your underlying case, I need to ask you if you want to. Hold on. You've got another case going on, right? That's where you've got a violation of probation. You have a probation case, right?
Yes, sir.
Okay, that's the one I'm talking about.
Yes, sir. That's
Okay,
what I'm here for.
you got an attorney. You're here on a violation of that probation. That's like a new charge.
Okay.
Okay, so you want to have an attorney appointed for that one too?
Correct.
Yes. I assumed you did, but I have to ask you formally. Hold on. I'll walk you through it. So, I'm going to appoint the public defender. I'm going to enter a denial on your behalf. And we're going to come back on January 21st, so you can meet up with your attorney. And Mr. Medina is your attorney.
Yes, sir.
So you can schedule something to get his card, and you can follow up with that, okay?
Did the court represent that Your Honor, does he already have a new law case as well? Or is it just a VOP?
It's just a VOP.
Okay. All right, just stop talking. Let us, sorry.
I don't have a copy. If there is, I'm not aware of it. Mr. Medina might be, but.
I've just given him my card for him to set an appointment.
Okay.
And he does need to fill out the public defender application again and turn that in on the first floor. Even though the court's appointed, you still need to fill that out. Okay.
Do you understand what's going on? You got it? Any questions? Now you can have any questions?
Okay.
Just step outside. Just call my assistant, set her on one minute. Fill that out.
Mr. Boyette.
Thank you.
Okay. So, let's go ahead and we'll start going through our docket, just our regular docket.
Judge, I just got one, actually one on the morning docket.
Yep, come on.
If I can call Xavier Banks.
Xavier Banks.
He's in custody. Your Honor, if I may also, there's one on the afternoon plea day docket. He is present. I've already talked to him, and we'll resolve it this morning as well, if the court permits.
Sure.
Judge, this is Xavier Banks. He's before the court on 24 CF 1509. Is this what you want to do? Do you have any questions? Sign it. Judge, this is Xavier Banks. At this time, he's going to admit the violation of probation. This will be a modification of supervision. It will be placed on 6 months of community control. That will be followed by the balance of regular supervision. He'll complete the original terms and conditions, maintain the withhold of adjudication, and all applicable court costs will be assessed. Since this is a modification, there's no score sheet. We may approach.
You may. State. Thank you. Mr. Banks, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So this is like a new charge, so gotta make sure and ask you the same questions I did before. You've gone over this plea agreement with your attorney, and you believe it's in your best interest. This will be a final resolution of this. You understand that? You're waiving the right to go to a hearing on this. Do you understand that?
Yes, sir.
This is what you want to do? You believe this is in your best interest here today?
Yes, sir.
Okay. Just want to make sure I hear it from you, okay? So based upon that, court will accept your plea agreement. There'll be a modification of supervision, and there'll be 6 months of community control, followed by the balance of the supervision under regular probation. Complete all the original terms and conditions, and you will be able to maintain the withhold of adjudication. That's important. And then all applicable court fees, okay? Those will be added on. Any questions? Okay, thank you.
Judge, on the afternoon docket, Aaron Austin, I think he's on the 1:30 plea day docket.
Got it.
I was just recently appointed to this case, but we were going to resolve it this morning.
Okay.
This is Aaron Austin before the court on 24 CF 2507. Sign and date there.
Youngbloods and yesterday?
23 CM 1736, and then there's 23 CM 2110. VOPs on both of those fees. Mr. Collins.
Right, that's the one that I asked you when you said all of Mr. Cox's pieces were continued, so we continued it. So
Those continued.
the next one's 212. Oh, on today's stuff, I was asking about yesterday's stuff, you said yesterday. A motion for continuance was filed, but we still.
Should we continue to the next?
Okay, I'm sorry. Go ahead.
Judge, this is Aaron Austin, 24 CF 2507. He's on the afternoon docket, but at this time, he's going to enter a plea of no contest, be adjudicated guilty, placed on 2 years of probation, be assessed $515 in court costs, $150 cost of defense. There's restitution in the amount of $2,062 to ULTA. No trespassing at any ULTA. The restitution is joint and severable with the co-defendants, and I've explained to Mr. Austin what joint and severable means. And supervision is concurrent. He is a resident of Mobile, and he's anticipating requesting to have his probation transferred to Mobile. I advise him he needs to check in with Fort Walton probation upon his release here. prior to getting it transferred. But I can give you his address in Mobile.
He has to apply for a transfer. It's a $100 application fee, and it's really up to state of Alabama if they accept him.
You understand?
Yes.
And I've also advised him that if he's not, his probation is not approved by the state of Alabama, he is in probation in Florida. But for probation, I can give you his address in Alabama if
He
you
would
want.
have to show us an ID for interstate compact transfer.
Judge, I believe the state will file a score sheet later.
Yes, Judge, I'll print it off at the office, bring it back this afternoon. If that's
Good.
acceptable.
I may approach.
You may. What is Ulta?
It's a makeup store.
It's a makeup store?
Right?
Okay.
Yeah.
Am I asking the wrong person?
It's a,
I also
it's
asked
a
that
beauty
this morning.
supply store, Judge. There's
What?
makeup and skincare and.
Okay.
It's like Sally's, but upscale.
What's that?
Sally's Beauty Supply, but upscale.
Above my pay grade. I just wanted to make sure that it wasn't Aldi's that,
Oh, no.
I wanted to make sure we were clear about where the no trespassing is. That's an important condition here.
Yes, sir.
So, Mr. Austin, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, you can put your hand down. So, you heard your attorney state the terms of your plea agreement, and those same terms are contained in the written plea agreement that I see you've signed. Just want to make sure, have you read the plea agreement, gone over it with your attorney in detail?
Yes, sir.
And you understand that by entering this plea agreement, you're waiving the right to go to a hearing, and this will be a final resolution of this violation of probation. Do you understand that?
Yes, sir.
And that's what you want to do? You believe that's in your best interest?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt on both counts. There'll be 2 years probation is the sentence, $515 in court costs, $150 cost of defense. Restitution, $2,062 to Ulta, and no trespassing at Ulta. And the restitution is joint and several with the co-defendants.
Yes, sir.
And you've had that explained to you.
Yes.
And when you say supervision is concurrent,
Between the two counts.
okay, so it's a total of 2 years. So it's 2 years for each count, but they run concurrent.
Okay.
So it'll be a total of 2 years probation. And that 2 years of probation is to give you a chance to pay your restitution. That's the main reason.
Right.
So you need to start bit by bit. Even if it's a little bit, start paying every month. You don't want to wait until the, close to the end, then you don't have the money and they're trying to violate you and put you back in jail.
Yes, sir.
So you gotta work at that,
Right.
okay?
Right.
Okay, you have any questions concerning what we're doing here today?
No, sir, I don't.
Okay. Thank you very much.
Thank you, Judge. That's all I have this morning and afternoon.
Thank you.
Your Honor, can I take an out of custody?
Sure.
It's Justin Hammett, that's 23 CF 461.
Okay.
Your Honor, the state and I have an agreement reached for Mr. Hammett. It is a community control offer. If the state would be inclined, he's asked to come back in January and take that offer.
That's correct, Judge.
So what we're doing today is we're continuing it until January 21st, and you're anticipating a plea at that time.
Yes, Your Honor, it's a community control offer, and given the holidays, it's going to be a bit difficult with the job and everything, so he's asked if we can do that, and the state had no objection to that.
Okay, so all we're doing today is we're continuing it until the 21st of January,
Yes, Your Honor.
9 o'clock,
Yes, Your Honor.
not 9:30.
Yes, Your Honor.
Okay. It might come, your attorney pled for you, so we kind of put it off to the side.
Thank you, Your Honor.
Okay, thank you.
Thank you.
Okay. So, which state attorney is handling Nicholas Brown? It's a status?
Actually, it's both of us, Judge. That one was with Ms. Kelly Simon as his attorney. There was a PTI for both our cases. I think the status was just to be sure that the paperwork had been filed, and I believe that Ms. Simon did confirm that it had been filed.
Okay, so that comes off?
That's our
Okay,
understanding.
very good. That's why I was going to just ask you kind of what was going on.
Yeah.
Okay, Okay. Ms. Farkas is up next, but if you all, who wants to go? Mr. Gates?
Yes, Your Honor, I'm going to go with the main bench, Your Honor.
Let's do it. First one is Heather Gares. Is that, well, you want to do the females first?
Yes, Your Honor, we can.
Travis, in addition to pretrial services of random UAs and weekly check-ins and pretrial services.
I had pretrial services because it wasn't on the original.
Do you have any thoughts on those check-ins already with?
No, I haven't.
Okay.
Yes.
And they're random, are they random? Yeah, random.
Your Honor, this is going to be Ms. Heather Garrett, court in 24 CF 1315. She is scheduled for a bond hearing. However, we have a bond agreement reached in her case, Your Honor. I'm hoping that.
Yes, she did, and she did not see any issues.
It's okay. I have an order to submit for the case, Your Honor. The state has agreed to modify Ms. Garrett's bonds to signature bonds. We're adding the condition for pretrial services and random urinalysis during the term of the bond, Your Honor.
Very good. Do you have an order?
It's
Or are you
gonna be,
just gonna
it's on
provide
the printer downstairs, so as soon as I can go get it, I'll
That's
bring it
fine.
to the court.
Okay. Thank you
Your
very
Honor,
much.
the state wants to put on the record that the state's offer will be revoked next pretrial in February.
The underlying offer, not on
The
the
current
VOP
offer that was sent to Mr. Gates, it was an amended offer.
Yes,
Yeah,
Your Honor.
right, not on the bond, but on the,
And Ms. Gears is aware of that offer. We've discussed it. I will talk with her more when she gets out of custody about that.
okay. Any questions, ma'am?
No, sir.
Thank you very much.
Thank you. Merry Christmas.
Two.
No, I don't.
And for just status purposes, Your Honor, with Ms. Gears, if we can continue her case to the February 10th docket.
Correct.
Hey, Ms. Glenn. Your Honor, this is going to be April Glenn before the court in 23 CF 663. We have a plea agreement to file.
Did you get that, Madam Clerk?
We'll let Ms. Glenn know she could see, but her father did travel down here. It's our anticipation she should be released later this afternoon.
Okay.
Use the score sheet.
Allow me to get it organized real quick. If I may approach with a plea agreement, Your Honor. No
You may.
objection to the score sheet.
Thank you. Would you announce the terms of the agreement?
Yes, Your Honor. Ms. Glenn's going to be entering a mission to the VOP before the court in 23 CF 663. She'll be adjudicated guilty, revoke and terminate her outstanding probation, $100 cost of prosecution, $150 public defender fee. She'd ask for 24 months from today's date to pay those fees for the sent to collections.
State?
That is the state's agreement, Your Honor.
Ms. Glenn, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Just want to make sure you've read through the plea agreement, you've gone over it in with your attorney, make sure you had all your legal questions answered. This is pretty straightforward. I understand there's not much really to even question you about it. So it's on its face, it's obvious why you're taking it. So it's obviously a good deal. So you have any questions regarding the plea agreement?
No, sir.
Okay. Based upon your testimony and the plea agreement, the court will accept your plea agreement. There'll be an adjudication of guilt on the underlying charges. The court will revoke and terminate probation. $100 cost of prosecution, $150 public defender fee. You'll have 24 months from your date of release to pay any of these outstanding court costs and fees. Okay, any questions?
No, sir.
Okay, thank you very much.
This is going to be Mr. Johnny Hill before the court and a couple of different VOPs, if I can grab his file for the court. He's before the court in 18 CF 2511, 21 CF 1038, and 24 CF 679. He also has a new law violation, 24 CF 2713 as well. At this time, Your Honor, if we can enter in denial on the VOPs. It appears the state has already filed an information in 24 CF 2713. If we can go ahead and enter a not guilty plea on that as well, and then move everything to February the 12th.
Very good. The court on the new law charge 24 CF 2713 will enter a not guilty plea and will deny the violations of probation that were announced, and we'll track all of them together to February, to the next pretrial date, which is February 12th at 9 a.m.
I'll come see you right now. It's going to be Benjamin Hoffman before the court and 24 CF 2303. We have a plea agreement to be filed, if I may approach, Your Honor. We'll have a score sheet, but it will not be a downward charge, Your Honor.
Okay, thank you. Would you announce the terms?
Yes, Your Honor. Mr. Hoffman's going to admit the violation before the court. He was previously adjudicated guilty. We're going to revoke and terminate his outstanding probation. Sentenced to 6 months in the county jail with credit for all time served. $100 cost of prosecution, $150 defender fee. He'd asked for 24 months from his date of release to pay those fees before they're sent to collections.
That is the state's agreement, Your Honor.
Thank you. Mr. Hoffman, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor, I do.
So you heard your attorney state the terms of your plea agreement. Those same terms are in the written agreement that you've signed. Just want to make sure that you read this closely, gone over it in detail with your attorney.
Yes, I have.
Had all your legal questions answered about the plea agreement.
Yes, sir, it is very.
Importantly, one of the things you're doing, this will be a final resolution of your case here of the violation of probation. But in order to do that, you got to kind of waive the rights to go to a trial, the hearing, and all that stuff. Believe that's in your best interest?
Absolutely.
To waive those rights?
Absolutely.
And you're entering this freely and voluntarily?
Absolutely, I am.
Okay. Based upon that, the court will accept your plea agreement. The defendant was previously adjudicated guilty on the underlying charges. The court will revoke and terminate probation. And you're sentenced to 6 months in the county jail. You'll get credit for all time served. Have a $100 cost of prosecution, $150 public defender fee. You'll have 24 months from your release from jail in order to pay those fees. And then it'll go to collections if you don't pay it by then. Okay? Any questions?
No, Your Honor, thank you.
Anything else, Mr. Gates?
No, Your Honor.
Thank you.
Holder. Your Honor, this is going to be Mr. Christopher Holder before the court at 24 CF 2468. The state and I have reached an agreement on the bond in this case. Again, I have an order downstairs for the court. Essentially, we're modifying all counts to $1,000 cash or professional. That'll be a total of $6,000 cash or professional. All other conditions will remain the same. It was set by first appearance, pretrial services, GPS monitor at the lowest cost per day, no access or possess internet-capable devices, no congregating or no being where minors congregate, and then no contact with minors. The state agreed, however, to allow him to have contact with his own children as a condition of that bond as well. I'll be following up with the order as soon as I can get it.
Very good. The only thing I would say to you, Mr. Holder, is pay attention to the requirements, because if you violate, they won't fool around. They'll just pull your bond and you'll be back in jail. So, but the court, based on the agreement, stipulation of the party, will amend the bond as stated by counsel. Okay? Thank you. Thank you.
And Your Honor, Mr. Holder is currently scheduled for February the 10th.
Okay.
We've already filed a written plea not guilty for the afternoon docket.
Very good. Is he on the afternoon docket, Mr.?
He was, Your Honor. I filed a written plea, so took him off that docket.
Okay.
This is going to be Mr. Timothy Johnson before the court in 23 CF 2583. If we at this time can enter a denial on his violation of probation and schedule him to the January 21st date, he has a new law violation misdemeanor that's scheduled for January the 6th, and my hope is that we'll have a resolution when we come back.
Very good. Court will enter the denial on behalf of the defendant, and we'll continue this matter until January 21st at 9 a.m. Okay?
King.
Your Honor, this is going to be Mr. Michael Keene before the court in 24 CF 2580. He's also, actually, I apologize, Your Honor. I think I have, make sure I get the right case numbers here. All right. I wrote down the wrong case number. Before the court is 24 CF 2021. That's on the morning docket. He also has an afternoon docket case of 24 CF 2532.
Travis, this question.
This is Mr. Jones?
Mr. Michael Keene.
Okay. Crossing me up here.
Mr. Jones is out of custody, Your Honor, and
Okay.
we'll handle that later.
Okay, very good. So are we dealing with something from the afternoon docket too?
Yes, Your Honor, we are.
Okay, go ahead. I'm sorry.
If I may approach, Your Honor.
You may.
No objection to this score sheet.
Thank
I
you.
do believe it'll be a downward departure for treatment program, Your Honor.
Okay, hold on just a second.
Yes, Your Honor.
Okay, go ahead, Mr. Gates.
Yes, Your Honor. Mr. Kine's going to be admitting the violation before the court in 24 CF 2021, and then pleading is charged in 24 CF 2532. Adjudication of guilt in all counts. In 24 CF 2021, we're going to modify and reinstate his probation. That'll be concurrent to 24 CF 2532. Extend his termination date by 12 months from the current expiration date. We're going to add the condition to successfully complete the Keaton program as a bars to bed and any aftercare. Waive the cost of supervision, $100 cost of prosecution, $150 defender fee, complete those original requirements. And 24 CF 2532, 48 months of probation concurrent with 24 CF 2021. Waive the cost of supervision, entering successfully complete the Keaton program, again bars to bed, any aftercare treatment required. Restitution in the amount of $1,663.30 to Roy Kurt Fairley. No trespassing at Hollywood Coin Laundry, 1 Alder Avenue, Southeast Long Beach, Florida. And no contact with Mr. Roy Kurt Fairley. And then the standard court costs and public defender fee.
That is the state's agreement, Your Honor, and this is a downward departure based on a legitimate uncoerced plea agreement.
Very good. Pronounce your last name Keene?
Keene, yes, sir.
Keene. Mr. Keene, would you raise your right hand, sir? You swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. So, just want to make sure you've heard the terms of the plea agreement that you have entered. And I see that those same terms that your attorney just announced are in the written agreement that you've signed. Just want to make sure if you read this closely and gone over it in detail with your attorney.
I sure have.
You understand that by entering this agreement, you're waiving the right to go to a hearing to contest this, force the state to prove their case. You're waiving all that in order to get a final resolution.
Yes, sir.
Believe that's in your best interest?
It is.
And you entering this freely and voluntarily?
Yes, sir.
Nobody twisted your arm to get you to enter into this? Okay. Based upon that testimony, the court will accept your plea. You've got two cases, 24 CF 2021 and 24 CF 2532. There'll be an adjudication of guilt in both cases with the underlying charges. And in 24 CF 2021, court's modifying and reinstating probation, and these probationary periods will be concurrent with 24 CF 2532. But on the 2021, extend and terminate the probation date by 12 months from the current expiration date, and add an additional condition of the probation to enter and successfully complete the Keaton program, bars to bed, and any aftercare program. The court will waive the cost of supervision, and then, but you are assessed the $100 cost of prosecution, $150 public defender fee, and you've got to complete any other original requirements.
Yes, sir.
In 24 CF 2532, courts ordering 48 months of probation. And again, it's concurrent with the other one, 2021. Waive the cost of supervision and have the identical enter and successfully complete the Keaton program, bars to bed, and any aftercare treatment. In this case, there's an additional requirement of restitution in the amount of $16.63 to Roy Fairley, and no trespass at the Hollywood Coin Laundry. It's got the address here, and no contact with Roy Fairley. That's important, those no contacts. They'll really bust you if you violate those. And then you've got $515 in court costs and $150 public defender fee for these. Those are all payable during the course of the probation, okay?
Yes, sir.
Any questions?
No, sir.
Okay, good luck, sir. You have 30 days to appeal the ruling, the sentencing.
Here, these are yours. Sorry, I was waiting to see yours then.
Your Honor, this is my client Rico Daniels, 24 CF 2584. My office just found out yesterday that this case was erroneously put in the south end. It is supposed to be a north end case, so we filed the motion to transfer it to the north end.
Okay.
I had filed a bond motion on Mr. Daniels' behalf, but I'll have to withdraw that and it'll be heard in the north end. I would have told you sooner, but we found out yesterday evening, so I apologize.
It's currently in the south end. I don't have any problem. If the state's willing to do this, I'll hear the bond hearing now. If the state wants, unless the state doesn't want to. Until you transfer it, I've got jurisdiction.
Rico Daniels.
I think it's Rico Daniels.
Daniels is the last name.
I just want to make sure that the state attorney has
We'll find this.
the case, yeah. Apologize.
Okay, so he's not even on the docket. Give me a second. What's the case number, Rachel?
Yes, he is on the docket.
24 CF 2584.
24 CF.
2584.
I'm sorry, Your Honor, it's not on the docket that I have. but
That you have.
Well, we will look at this. Do we want to hold him so we can look at that?
If we can maybe
Thanks.
pass Mr. Daniels right now, then we can come
Okay.
back to it.
The reason why I'm suggesting we do it now is it does look like there is at least some basis for consideration of a bond reduction. A lot of them I would discount out of hand, but
Thank you, Your Honor. We can
it does
come
look
back
like
to
there
that.
may be some substance to it that worth considering.
Thank you.
Okay.
I think next is Zachary Dispinette, 22 CF 745. This is a VOP return on a capias that was issued. I've spoken with the state attorney and I just received the offer. It is a DOC offer, so if we can continue it to the January date, so I have time to discuss it with Mr. Dispinette.
I've got this as a sentencing
Yeah, you
hearing.
can write it now.
It wasn't, I don't believe it was set as a sentencing hearing, Judge.
I think I can clarify. So it was a sentencing hearing back in July.
Right.
Mr. Dispinette failed to appear for that, so a capias was issued, so I think it was put back on the docket as a VOP. I get, maybe it was erroneously put on as a sentencing.
Okay.
If we can continue it, just, I guess, to figure
I was
out
kind of wondering what it was too,
what's
so
going on.
that's fine. Okay, so we're going to continue this till what? The next one, 1/21?
Yes, please.
January 21st. Okay. Thank you.
Eccles. Your Honor, next up is Kendall Eccles, 22 CF 3117. Hey, Mr. Eccles. The state and the defense have reached an agreement that I have reviewed with Mr. Eccles. I'm just going to have him sign it.
Okay.
Got 24 months to do that, so not a rush. I mean, always good to do it, but. Okay. That's yours. All right, may I approach, Your Honor?
You may.
I'm just questioning, is there?
Thank you. Would you announce the terms of the agreement, please?
Yes, Your Honor. In 22 CF 3117, there is a single third-degree felony VOP. There was a previous adjudication of guilt on that charge. Mr. Eccles will admit the VOP, receive credit for time served, revoke and terminate supervision, public defender fee, and I may have forgotten to put in the cost of prosecution, and then we'll have 24 months to pay those costs. I can make that edit.
Okay. Mr. Eccles, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of the plea agreement. Pretty good deal. So I understand why you're accepting it. It's not even worth really asking you about why you are, but I just want to make sure you've gone over this with your attorney and you're satisfied this is in your best interest. Based upon that, the court will accept your plea agreement. There's an admission of the VOP. Your sentence is technically credit for time served, and court will revoke and terminate supervision, so you're done. You do have 24 months to pay the outstanding public defender fee and the cost of prosecution. Okay? Okay. Good luck, sir.
Thank you.
Your Honor, next up is Mr. Figures, 23 CF 1120 and 23 CF 1390. The state attorney and I need 1 minute. Your Honor, I need to make an edit to the plea agreement, and so we need to pass Mr. Figures for 1 minute if we can.
Okay.
Give me 1 second.
Carl Flack.
We'll have to pass him for a second.
Okay.
So we
Yeah,
can bring him
hold
out
him.
in a minute. Sorry.
Yeah.
Next up is Carl Flack, 23 CF 1221. The state and the defense have reached an agreement in this case that I've reviewed with Mr. Flack. I'm just going to have him sign it now. It goes to a civil lien. Yeah. If I may approach you, Honor?
You may.
I've got the score sheet as well.
Would you announce the terms of the agreement?
Yes, Your Honor. In 23 CF 1221, there is one felony, third-degree felony VOP. There is a previous adjudication of guilt. Mr. Flack will admit the VOP, receive credit for time served, revoke and terminate supervision, public defender fee, cost of prosecution, and 24 months to pay those costs.
That is the state's agreement, Your Honor.
Mr. Flack, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide the court is the truth, nothing but the truth, so help you God?
Yes.
So I see you heard your attorney state the terms of the agreement, and those terms are in the written agreement that you've signed. Just want to make sure you've gone over it in detail with your attorney. Make sure you had all your legal questions answered.
Yes, sir.
You're waiving the right to go to a trial. It's obviously a pretty straightforward and generous plea agreement. So I understand why you're taking it, but I just want to make sure you've had all your legal questions answered, and you're doing it freely and voluntarily.
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. There's an admission of the VOP. Your technical sentence is credit for time served, and the court will further revoke and terminate supervision, so you're done with supervision. You can get out immediately. You do have the $150 public defender fee and $100 cost of prosecution of 24 months after you get out to pay it before it goes to a lien. Okay? Any questions? Okay, good luck, sir.
Thank you, Your Honor. He was just asking about some court costs, so I was explaining
Sure.
to pay them with the clerk.
Gotcha.
Your Honor, next up is Dustin Ford, 23 CF 2141. The state and the defense have reached an agreement in this case as well. Right here.
Yes, and the score sheet's behind it.
I have gone over it with Mr. Ford. I'm just going to have him sign it. Put the date. No, it's totally fine. It's easier for me to write. All right. May I approach your Honor? I
You
have the
may.
score sheet as well.
Would you announce the terms?
Yes, Your Honor. 23 CF 2141. There is one third-degree felony VOP count. There was a previous adjudication of guilt. Mr. Ford will admit the VOP, receive credit for time served, revoke and terminate supervision, public defender fee, cost of prosecution, and 24 months to pay.
Very good. Mr. Ford, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. Obviously, you've signed the written plea agreement, says the same thing. Obviously, a good, very straightforward and generous offer, so.
Yes, sir.
I don't think there's any question. I don't even have to ask you whether you think it's a good deal. So, just want to make sure you had all your legal questions answered by your attorney about the plea agreement.
Yes, sir, I have.
Okay. And based upon that, the court will accept your plea agreement. There'll be an admission of the VOP. Your technical sentence is credit for time served. The court will further revoke and terminate supervision, so you're done with probation. You do have the fees and costs, $150 public defender fee and $100 cost of prosecution. You'll have 24 months after you get out to pay those, pay them to the clerk, okay? If you don't pay them at that point, it goes to lien, and they'll go after your driver's license and all that stuff. Okay? Any questions?
No, sir.
Okay. Good luck.
Thank you.
Ms. Farkas, I think you're,
Yes, apart from the couple that we had to pass. I
right.
think that's it for me right now.
Why don't we go ahead and take our morning breaks? Mr. Medina, I have a question for Mr. Medina.
You want me to grab him, Your Honor?
Yeah. Could you grab Mr. Medina real
Yes.
quick?
Give me 1 second.
And Your Honor?
She's doing it.
And what I'm going to ask him about, whoever's handling it, is the Perez sentencing. Who's handling that?
That's mine, Your Honor.
Okay, I'm sorry, Ms.
No, Your Honor, I
Bassam.
just, I did see Mr. Bishop was still on the transport list, and we did handle him yesterday. So I just wanted to go ahead and make sure of that.
Okay.
He did not.
Okay, because I saw him on our list here, so I just want to make sure. We took care of it yesterday.
Okay.
Thank you, just want to make sure.
Thanks, appreciate it.
Your Honor, you were asking about Ms. Perez?
Yeah, I'm waiting for Mr. Medina.
Yes, sir.
So we dealt with Mr. Bishop yesterday?
Yes, sir, we did.
Yes, Judge, we dealt with David Bishop yesterday.
Okay, would you all, would Ms. Sharpless, Mr. Medina approach?
Yes, Your Honor.
Hi, this is Alex Barthay from the UPS store in Crestview, Florida. We also have Eglin Air Force Base in Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should start letting you know that we're getting close to having parts of the country each day cut off. So go to ups.com. You could see the calendar on the website. Also, on this ad, you're going to also have the flyer that shows the dates, so you can fine-tune whatever it is that you're trying to ship out to a loved one, what part of the country. If you're sending to deployed men or women, to APOs, FPOs, I would suggest getting the mail sooner rather than later, because it's going to take during normal times 10 to 12 days. 10 days, 2 weeks is probably a better gauge on shipping. So get those packages going to our deployed men and women around the world so that they can have a happy Christmas as well. In other parts of the U.S., you can also refer to the post office's website for those particular locations. Shipping outside the U.S., give it time. So again, sooner is better. On behalf of your Crestview, Eglin Air Force Base, and Fort Walton UPS stores, we want to wish each and every one of you a very Merry Christmas and a prosperous New Year's. If you need any help, come into any of our stores and we'll be glad to help you. All right, see you next year.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those Hi, I'm attorney Michael Gilbert, and from all of us here at Warrior Law, we wish you and yours a safe and happy holidays.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Hi, this is Alex Barthay from the UPS store in Crestview, Florida. We also have Eglin Air Force Base in Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should start letting you know that we're getting close to having parts of the country each day cut off. So go to ups.com. You could see the calendar on the website. Also, on this ad, you're going to also have the flyer that shows the dates, so you can fine-tune whatever it is that you're trying to ship out to a loved one, what part of the country. If you're sending to deployed men or women, to APOs, FPOs, I would suggest getting the mail sooner rather than later, because it's going to take during normal times 10 to 12 days. 10 days, 2 weeks is probably a better gauge on shipping. So get those packages going to our deployed men and women around the world so that they can have a happy Christmas as well. In other parts of the U.S., you can also refer to the post office's website for those particular locations. Shipping outside the U.S., give it time. So again, sooner is better. On behalf of your Crestview, Eglin Air Force Base, and Fort Walton UPS stores, we want to wish each and every one of you a very Merry Christmas and a prosperous New Year's. If you need any help, come into any of our stores and we'll be glad to help you. All right, see you next year.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those. Hi, I'm attorney Michael Gilbert, and from all of us here at Warrior Law, we wish you and yours a safe and happy holidays.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his
Hold on.
Got ahead of myself.
Doing two things. I'm sorry, start over again.
Yeah, that's my fault. I apologize.
Sorry.
Rico Daniels, 24 CF 2584. I spoke with the state attorney, and because of the mix-up, I had his case, but it's apparently assigned to the North End state attorney, Ariana Leone. So Ms. Sharpless isn't prepared to argue the bond motion today because I don't know if she didn't receive the bond motion. Of course, it's not her case. So there was a clerical mix-up, and I don't think that.
Okay.
I'm not sure if there's anything that we can do, if we could pass it to the afternoon.
Your Honor,
But-
the bigger issue is that there's a victim on this case, and because this actually is a Crestview case, so I'm unsure why Ms. Farkas got assigned to this case, but this is actually a Crestview case, and because it wasn't set with Judge Conteric and it was set with Your Honor, I don't think the victim was notified of this bond hearing. So that's the bigger issue.
That's fine.
Your Honor, I don't know
Y'all
if.
don't want to do it, I offered to do it because,
Mr. Gibbs was appointed originally, and then Ms. Farkas filed her notice.
Yeah, it still counts.
Okay.
yeah, I mean,
Someone's got to contact.
y'all work for the same offices, you're just transferring them internally, but if you all have things that you don't feel like you can do it, then I'm not going to force it. So, what do you want me to do? What is the next day, hearing date on this? I know it's going to be transferred, but,
It's already been transferred. It's February 24th.
okay.
And I think he's, my assistant put that his arraignment date there would be December 26th. Is that right? Okay. I don't know if we can just, if we should just wait and let him be arraigned there. Okay.
We're not going to take any action today.
And
Okay.
I will speak with his North End attorney about filing the same bond motion and maybe hearing it then.
And you'll just need to file a notice of appearance too, because you filed a notice of appearance.
Yes.
I mean, you've already filed it, the motion's filed. Just,
Right, so I guess
I
if
mean,
you
he
just
can
argue
do
the
what he
same
wants
motion.
with it, he may not take it up and argue it, but you don't have to file another motion.
Not if I have anything to do with it.
I
Thank
mean,
you.
you don't have to file another motion, you only need to file one.
Your Honor, this is Leroy Figures. We're bringing him out again. The state and the defense have reached an agreement. Sorry, I can give you the case
Go ahead.
numbers. So there's two VOP cases, 23 CF 1120 and 23 CF 1390. And then there's the new law case, which is 24 CF 1084. So we are going to be addressing all three today in turn. So the state and the defense have reached an agreement in the 23 cases, the VOPs only. If I can start with those and approach with
Okay.
the agreement. And the score sheet is there as well.
Go ahead.
There was a previous adjudication of guilt on both the counts there's two counts total, two cases. 23 CF 1120, Mr. Figures will admit the VOP. He'll be sentenced to 13.95 months DOC with credit for all time served to run concurrent. Revoke and terminate supervision, public defender fee, cost of prosecution, and most importantly, the state stipulates that all time has been served and he's eligible for immediate release. So he does not need to be transferred to DOC. Excuse me. 23 CF 1390 is exactly the same. Admit VOP, 13.95 months DOC, credit for all time served. Revoke and terminate supervision. State stipulates that all time has been served and defendant is eligible for immediate release.
So, There's 3 cases, so what are we doing on the
Yes,
third?
and then the third case is 24 CF 1084. In that case, Mr. Figures currently has $5,000 cash or professional bond on each count. There are 2 counts. And I have an order on an unopposed motion for bond modification where the state is agreeing to signature bonds with pretrial services and GPS monitor at $1 per day in that case. So we're leaving open the newest case and resolving the VOPs.
Okay.
If I may.
State?
That is the state's agreement, Your Honor. If we needed, I know that's unusual, but if we need to talk about it some more, I would ask to approach. It is.
I understand. So, Mr. Figures, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth?
I'm sorry, Your Honor. Mr. Figures had a question for me.
That's right. You all right? You got everything squared away?
He was just asking about when the GPS monitor would be attached. I don't know. Yeah, they're not here. He's saying that they come on Fridays. It's my understanding that they come as soon as possible. I'm not sure if they'd be able to get here today.
I'm getting one for misdemeanor, 48 hours.
Okay, I apologize, Your Honor.
It's all right. You don't have to apologize.
Okay, we're good.
You good?
Yes.
Okay, Mr. Figures, would you raise your right hand, sir? I need to swear you in. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So you heard your attorney state the terms of the plea agreement, and those terms are in the written agreement that you've signed. Obviously, pretty straightforward. You'll get a credit for time served, sentence of 13.95 months.
Yes, sir.
But I just want to make sure you have had all your legal questions answered and understand you are waiving the right to go to a hearing on it. Understand why, but you do have that right. I just want to make sure you acknowledge that.
Yes, sir. I understand.
Okay, and you believe it's in your best interest to enter into this agreement here today?
It is, sir.
Okay. Based upon that, the court will accept your plea agreement. In both cases, 23 CF 1120 and 23 CF 1390, these are both VOP cases. Courts having this identical sentence of 13.95 months DOC, and you will get credit for time served. These will be served concurrently, and the court is revoking and terminating supervision, and there's standard fees and costs. The court, importantly, obviously, the state stipulates that all time has been served, so the 13.95 months, the credit for time served is more than the 13.95 in both cases, and you're eligible for immediate release. And you'll have 24 months to pay the public defender fee and the cost of prosecution before it goes to a lien. Okay?
Yes, sir.
The court will also has signed the stipulated order on the other case, 24 CF 1084, the new case, allowing for a signature bond with certain requirements, pretrial service requirements. Okay?
If Ms. Sharpless and I may approach
You may.
briefly.
Clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Okay.
Hello.
Thank you, Your Honor. I apologize for the delay.
See you, my Mr. President. Thank you.
Okay. I think that's a wrap for you, Ms. Farkas, for this morning.
Yes, I believe it is.
Okay. So,
Let me get that out of your way.
Mr. Gates, you only have one more if you want to do you want to do the Jones, or?
I don't see Mr. Jones present, Your Honor.
So, what do we need to do with that?
Your Honor, the state's requesting a capias.
It was set as a PTI recall sentencing, Your Honor.
Mhm. Any legal objection to the request?
Other than to ask court to consider setting some sort of signature bond, because Mr. Jones does live out of state, and it was a PTI.
Your Honor, he failed to appear last time, and we had recalled the capias.
Court will issue a no bond capias. If he gets here today, we'll maybe address it, but
Yes, Your Honor, I think that concludes my business all the way about it.
you may. Thank you.
Your Honor, I have nothing further this morning, maybe.
You may.
May I approach with score sheets that I have
Sure.
from yesterday?
Hold on just a second, Mr. Medina, and we'll get going with yours. Thank you. Okay. Okay, Mr. Medina, you may proceed, sir.
We're going to get Antonio Marquise Belbetz out here, Your Honor.
Okay.
It's Belbetz. Oh, Alan first, fine. I'm sorry, yeah, Alan first, yeah. I'm sorry. I saw Belbetz in the queue, I did not see Mr. Allen. Of course, go with him first. Your Honor, can I give him a chair? He's got medical issues.
Sure.
Because this may take a few minutes. Can I just move over there to where the judge can see, and I'll just put you right there, okay? Thank you. Your Honor, C. Medina with Anthony D. Allen, 21 CF 282. This is scheduled for a status conference this morning, and to explain the court's to explain to the court the situation as I understand it. He was sentenced on October 17, 2024, so a couple months ago, to Phoenix House. After that happened, he already had some medical issues, but the medical issues became more acute, very serious. We've been in touch, as has the state attorney's office, with the jail on a fairly regular basis over the last month. And basically the jail encouraged us, caused us to reach out to Phoenix House based on the current medical situation. Would Phoenix House still take him? And basically said no. The Phoenix House said, no, we can't take him. So he's in a situation where he cannot do the sentence that was imposed on October 17th. However, I think we potentially have a workaround. One option would, of course, be that he could ask to withdraw his plea and we could kind of start over on the VOP, but he does not wish to do that. And we can probably avoid that through, if the state may oppose this on some level, but I think also sees the sensibility of the following. Basically, modify the October 17 sentence to allow him to go on community control rather than extend his probation for 1 year on drug offender probation with Bars to Bed Phoenix House, have him go on 1 year community control, have it be subject to what the jail we were in communication with Major April McDaniel at the jail yesterday. The jail is actually doing something that I was not previously familiar with, where their medical unit helps him get referrals to provide assistance on getting the medical services that he needs. So basically, we could make it a condition of the community control that he coordinate with the jail medical unit to ensure that he's getting whatever treatment is needed. Maybe that's over the top, but the jail, particularly Major McDaniel, wanted to know, and I can read the language, but basically she said, I saw, and this was her, may I just read this? It's about two or three sentences. I saw that Mr. Allen has a hearing tomorrow to address the status of his case. I thought you might both appreciate knowing that our medical team is looking at him as a candidate for our medication-assisted treatment and are working with outside resources to make appropriate referrals should the court take action tomorrow that would result in his release from custody. We're committed to helping inmate Allen transition to the community in a way that encourages his rehabilitation. So the jail's really going over and above.
So, read it again. I want to reference one of the terms they used.
Yes, they said
medically assisted.
The medical team would basically, they used the term candidate for our medication-assisted treatment. So
what is that?
I don't know what it means.
Well, somebody needs to let me know. What my question is it medically assisted substance abuse, or is it dealing with his medical condition? You understand? That's the big differentiation. I don't need all the particulars, but are they talking about medical? Are they talking about, with one of the medically assisted substance abuse programs?
I was taking it to be as for his medical treatment because it was the medical team.
Kind of dancing around it. Are you willing to? We can approach if you want, but
we can also.
I don't know what the medical issue is, and you don't have to say it in public, but you can approach if you want. I don't know. Is it?
He's okay to. He has a lot of major medical. Are you okay with just saying what the medical issues are? You'd be saying it is on camera. Would you rather approach or you?
Yeah. Let's.
We'll approach.
Yeah. You can just stay there, and do you know what it is?
I don't have it.
Okay.
It's complicated. I don't know all.
Come on now.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Arraignments Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Hi, this is Alex Barthe from.
Okay. So the question is, so Phoenix House, I understand, based on the medical issues, can't take him. So now we're back. That's the question where we're at.
Your Honor, may I explain one thing that I think is important in terms of the flexibility of the court?
Sure.
Just for the courts to be putting in the right box. Because it would be a modification that we're requesting, not a revocation and termination, it's technically not a score sheet issue, so there technically does not have to be a basis for a downward departure, because it would be within the discretion of the court to modify the probation to community control for 1 year with whatever terms and conditions, including substance abuse evaluation and treatment, the court wished to impose. So I just wanted the court to be aware that even if the state's attorney's office is not prepared to go along with it, the court has the discretion. Thank you.
So, I mean, are we making this decision now? Are we arguing this now? Or, I mean, this was here as a status.
Yeah.
You know, I don't know whether
we could.
State's even prepared to make arguments. So I don't, you know, I'm not,
I think
not
it's
trying to ram this thing down.
I think it's in the best interest of the taxpayers of Okaloosa County, and the jail's certainly done everything possible to make it clear that it was trying to coordinate for his release today. But we could schedule it for sentencing. I'm just not sure it would be done this year. We could bring him back next week as the courts saw fit. But I know the calendar's running out.
What the state, is the state willing to, do you guys want to try and make arguments? Or I'm not gonna jam you if you know, we're here. This was a status conference, like, status is just like, hey, where are we at with this case? This is a unique situation. I haven't had this happen, you know, in the 3 years I've been doing the criminal here. So
forgive me, Judge. I think if Mr. Medina and I can figure out what the jail's actually talking about.
Sure. I don't have any problem with that. It seems, I'm clear what they're talking about now. I don't think they're talking about substance abuse. They're talking about his medical conditions.
That's my understanding as well.
Yeah.
So we can
but you can figure that out, what it entails. Why don't we come back for let's
December 18th? Is that the day?
I think it's, what's my December 17th? What do we got on that?
I know I'm going to be here on December 18th.
Not in my court.
I thought so. I thought that's
what do we have on
Betts
December? Am I wrong?
16.
Yeah, I know, but Mr.
It's
Betts.
December what? 17th.
So for some reason, the notice for hearing of Antonio Bell Betts, which is another issue, does it not say the 18th? There may be a mess up on our notice of hearing in another matter, Ms. Godfrey. I'm just letting you be aware, because for whatever reason.
He has hearings on the 18th, yes.
The court has hearings on the 18th, yes. Okay. But those are specific, so the miscellaneous date's the 17th.
Right, the regular miscellaneous date is the that's my last
I didn't realize, I'm sorry, Judge,
that's
I didn't realize.
Now I'm visualizing.
Basically, we come to court every day for the, except for tomorrow.
See, it seems like it. Why don't we just call it a resentencing? And we'll come back on that date and you guys can make your arguments.
That sounds
good. We'll
Your
figure
Honor.
out you can get whatever information in the interim. And and we'll,
Would that be 9 a.m. on 12/17, Your Honor?
We only have 10. That's next week.
yeah, why don't we put sure, just do it then, but we'll do his last.
Yes.
Because his is gonna take a little more.
Understood, Your Honor. Thank you. That's very
Do
reasonable.
you agree, State? Is that a good?
I agree. I just request, competent evidence of whatever medical issues there are, like before, so I can look at it.
I have no access to medical records. I'm leaving on a family issue tomorrow. I will not be in the office. I'll be in court Monday and Tuesday. I have no way of providing his medical records between now and Tuesday. So,
I mean,
please
obviously
talk to
the jail.
Please talk to the jail. He will waive on the record. Are you willing to waive that the state can talk to the jail medical team and April McDaniel?
I mean, obviously they know because they're making statements.
Yes.
Hi, this is Alex Barthay from the UPS store in Crestview, Florida. We also have Eglin Air Force Base and Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should start letting you know that we're getting close to having parts of the country each day cut off. So go to ups.com. You could see the calendar on the website. Also, on this ad, you're going to also have the flyer that shows the dates, so you can fine-tune whatever it is that you're trying to ship out to a loved one, what part of the country. If you're sending to deployed men or women, to APOs, FPOs, I would suggest getting in mail sooner rather than later, because it's going to take during normal times 10 to 12 days. 10 days, 2 weeks is probably a better gauge on shipping. So get those packages going to our deployed men and women around the world so that they can have a happy.
I'm just trying to facilitate so you get the information you need so you can make your arguments, okay? Okay.
I do have a patient authorization. I hope the jail will accept it, but he will sign it right now, allowing the state, okay?
Good.
It's a
Very good.
patient authorization for use and disclosure of protected health information. I will go ahead and allow him to sign it here, right there, and I'll fill in the rest, and you consent, right?
Yes, sir.
All right.
You get the award for the day of coming up with unusual documents.
Well, just get them, just fill that out. Okay. And then hand it to Cody.
Okay.
Thank you, Your Honor. We're good.
Okay.
All right. Thank you. We're good. Thank you for sure. Good? Do you have any questions? Your Honor, Steve Medina with Stephen M. Bayshore, B-A-S-H-O-R-E, 23 CF 1582. Okay, thank you. Okay. This is Mr. Bayshore. Thank you. Just making a copy on my phone, Your Honor. Just take a second. And I am approaching Your Honor with a VOP agreement and a score sheet that does not require a downward departure. Did you see that 43.10? It's a high score, but not more than 44, so it's not a DOC.
Thank you.
Thank you.
Would you announce the terms?
Under the terms of the agreement in 23 CF 1582, in Mr. Bayshore's case, he will be entering a violation of probation agreement under which he will be admitting the violation. He was previously adjudicated guilty on these two charges that are part of the felony VOP. They will be reinstated and modified to add 6 months community control in lieu of the next 6 months of drug offender probation. So basically, he was given 24 months drug offender probation followed by 24 months standard probation. The next 6 months are going to be on community control. Then he'll go back to drug offender probation for however much time was remaining on drug offender probation, and then that will be followed by 2 years of standard probation. That's still the case. But just the next 6 months are community control. He will also have $71.85 cost of transportation to Okaloosa County Sheriff's Office. He will also have to complete his original requirements. He will also have a $100 VOP fee and 150 public defender fees. That's the agreement, Your Honor.
What were the violations in this case?
Your Honor, the violation was a driver's license charge for which I understand in Santa Rosa County he paid a fine. It was as he explained to me, represented to me, there was work-related travel that he shouldn't have been doing because he was not allowed to drive.
Okay.
And I believe there was also a failure to report on this one that,
I'm not seeing that, ma'am.
maybe I'm getting him mixed up.
It was
with
only
another
driver's
person.
license for Santa Rosa County, and he had graduated from Keaton and was also passing all his drug tests and remaining sober.
I'm sorry, Your Honor, I misspoke. I got him mixed up with another person, but also he had a special condition of no driving, Your Honor, so his license
Yeah, you
was
figure?
suspended.
It'll be for a while, no driving. It's the core issue. Mr. Bayshore, would you raise your right hand? I'm just wondering why you're getting such a sweet deal, but, you know, good for you. You got a good lawyer. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of your plea agreement, and I see those same terms are generously written down. And I just want to make sure that you have reviewed this closely, gone over it in detail with your attorney.
Yes, Your Honor.
And you understand that by entering this, you're waiving the right to go to a hearing.
Yes, Your Honor.
This will be a final resolution of this violation of probation.
Yes, sir, Judge.
Okay. And you're entering this freely and voluntarily?
Yes, Your Honor.
Okay. Well, I understand why. So based upon that, the court will accept the plea agreement. There was a previous adjudication of guilt, reinstate and modify, and add 6 months community control in lieu of the 6 months, the next 6 months of a drug offender probation, and then complete the remainder of the supervision as otherwise required. You must complete the original requirements plus additional standard fees, and then the unique cost of transportation, $71.85. So, anyway, pay attention to this. You know, when you, as I often tell people, I think you understand this, you know, they start off with a diversion, pretrial, and then you get probation. People get a lot of breaks along the way. Okay? Then they get drug offender probation, and then they get community control. What's next, Mr. Bayshore?
Prison time, DOC.
You got
on
it.
the road.
So, you understand the game. Let's try and keep it straight, man. You come a long way. You're saying you're staying clean, but you know these are serious charges, and when they're serious charges and you violate, they really bust you out. And then when you finally do go down on DOC, they got a long list in there. It's got a lot of numbers before it. So this is your chance, man. Take advantage of it. Stay clean. Okay, good luck. Mr. Medina.
I just wanted the court to be aware that this was basically a situation where the probation in its order, in its report, did recognize that he had done some good things and aftercare. So it was leaving it to the discretion of the court. Oftentimes in this situation, if it had wanted jail or DOC, it would have asked for it. So I think the state's only going along with it because probation was leaving a lot of flexibility for the court. Thank you.
Well, again, oftentimes isn't appreciated, but you know, people get credit when they're working. This is not easy to be on community control or drug offender. It's a pain in the ass, and it's hard to keep up with your life and your job and all that stuff. But we need to get credit when you do it.
Yes, sir. Thank you, Your Honor.
Anyway, good luck.
Thank you, Mr. Fields.
Meet up with probation there.
Take care. Thank you, Your Honor.
Your Honor, Steve Medina with Antonio M. Belbetz. The cases that are on for status today are 23 CF 483, which is the new law case, which is set for December 18 sentencing, and also the 19 CF 1261 VOP case. And at this time, we don't have an agreement, but basically Mr. Antonio Belbetz is going to admit on the record the VOP so that it can be sentenced at the same time on December 18th with the new law cases. And it would be, there's no agreement, it's just.
So you're basically it's like a plea to the bench.
Yes.
An admission to the bench.
It's an admission to the bench. He is specifically putting on record that he's reserving whatever rights of appeal he has in the VOP case as well as the new law case. That would be preserved through the sentencing process, but there would be no impediment to having a global sentencing on December 18th.
State?
That is a conversation Mr. Medina and I had. Your Honor, the PSI has been filed with the court. The state is having his fingerprints compared for the court to consider habitual felony offender sentencing. I talked to Mr. Medina, and we do believe it's going to be necessary for the FDOE analyst who compares his fingerprints to be present to testify in the court that his fingerprints are that Mr. Betts is the person who's previously pled to certain felonies. If the state was asking if the court would consider allowing that analyst to appear by Zoom from Pensacola. Okay. So I will email Your Honor's office and ask for a Zoom link for that. And Mr. Medina previously represented he wouldn't object to that, but I do believe he does want the analyst present, and the analyst will need to testify. There's no stipulation reached as to HFO sentencing and Mr. Betts' designation as HFO.
So my question, as it relates to what we're doing here today, is with I'm going to call it plea to the bench, whatever, however we want to term what Mr. Belbetz is doing this morning, whether that is a part Well, it's not, because they've already done the PSI. They've already done the pre-sentence investigation. Does that change their recommendation? Does, what should we do in order to include this violation in with the other sentencing?
And Your Honor, that's a good question. I do believe that probation I thought that they had included the VOP case numbers.
Your Honor, I haven't studied it carefully, but basically they were fully aware that there was a pending VOP issue, and did, very clearly state that he has violated probation many times. So I think that it would be anticipated that any sentencing testimony that was put forward by the state would be encompassing everything. So as well as the fact that because Your Honor sat through the jury trial, the court is very well aware of the facts and circumstances. So I don't think there'll be any impediment to a global sentence.
And Your Honor, probation's recommendation is incarceration deemed appropriate by the court. So yeah, I think that it would be consistent with probation's recommendation to have considered the violation of probation. So I don't think that's an issue.
Do we need, I'm sorry.
I was just going to say, is the one thing that this facilitates is a more clear score sheet, because otherwise, I mean, it would be kind of weird if we were having another sentencing. But so this way, I think the state will just make sure the score sheet doesn't need to be amended. But basically, I think it already had VOP points on it.
It did, Your Honor.
Okay.
May I judge? Sure. One other thing related to the score sheet is in the trial, the defendant, through his testimony, we have reached an understanding that the state had proof of so many felony convictions. I think it was 8. I can't remember. But if the state will please consider, does there need to be any adjustment of the prior record points to be consistent with that? In other words, you think the prior record is correct, you just didn't have the certified convictions for all of them? I can't remember why we did 8 or 9.
Then the number was based on the number that was on the score sheet, yeah.
Okay.
Okay, so my final question here, just for today, do we need to, is there a written plea, essentially, an admission? Do we need to, certainly we need to put it on the record. He hasn't said anything. I'm going to put him under oath and ask him whether make sure he understands that this could impact your sentencing. Make sure you need to understand that.
Your Honor, I basically think he would be changing his previous denial to an admission. There was only one underlying charge, possession of controlled substance, third-degree felony in 19 CF 1261, the VOP case. Mm-hmm. So that's a third-degree felony, and he would be admitting to that.
So he has an absolute right to admit to it, so I don't even think I need to inquire, really, because he has a right to, you always have a right to admit or enter a guilty plea to the bench. So I don't think I need to, do I need to inquire?
I think the court probably just wants to make clear that it's just not me talking, that he does admit it. Because
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state that you were entering an admission, and I'm just going to use the kind of vernacular, to the bench. In other words, you're not doing it based upon a comprehensive plea agreement. You're admitting it basically in order to make sure that it's included in the overall sentencing, but that it may impact your sentencing. You understand that?
Yes, sir.
And Mr. Medina was correctly stating your position that you did wish to admit to the bench without any agreements as to the effect of that. Is that
Yes,
correct?
sir. Yes, sir. I'd just like to preserve my right to appeal. That is all.
Okay, and you do have that right.
Right.
And that's been stated as well.
Yes, sir.
Okay. Okay, very good. So we'll reconvene then on the 18th and for sentencing.
Thank you.
Thank you.
And just for the record, I did give him a copy without staples of the pre-sentence investigation for his study. Thank you.
Sure.
Mr. Brooks.
Your Honor, Steve Medina with Lee A. Brooks. We have a violation of probation agreement that will result in a plea to the bench with a cap, and he is signing it. I've been over it. He doesn't read well, so I went over it very carefully with him in its entirety, and he is signing it. May I approach, Judge?
You may.
And there is not a score sheet at this time. The state will be providing the score sheet at the sentencing hearing, but he does score prison. I think the last time that I discussed it, we're anticipating 52.8 months lowest permissible prison sentence, but this is a 60-month cap agreement. May I approach, Judge?
May.
But whatever the score sheet is, it'll be provided at the time of sentencing.
So we're gonna have to, are you all gonna be seeking a PSI, I assume?
Defendant was waiving that, Your Honor. He's had a lengthy record. The VOP report is pretty detailed. He went to Keaton. He successfully completed Keaton. So probation is very well aware of him and basically wants him to do Phoenix House. He got accepted to Phoenix House. The state is not willing to accept that. So the hearing, we don't see the need for a PSI. We would rather waive it and expedite matters.
Okay.
And may I see that, Judge? I think I may have accidentally checked the withhold box as well as the...
You did.
Because it was a previously adjudicated guilty, so I'm just crossing that out there. Sorry. Did the court have any other questions, or should I recite the agreement?
You just recite the agreement.
Yeah, he's pointing out, Your Honor, that he was also accepted by Master's Touch Ministries of Pensacola, and he's free in his testimony at sentencing to ask for that as an alternative, but...
that'll be something that you want to bring up at the sentencing. Okay.
Okay. The agreement does touch on Phoenix House, though. I'm happy to... May I have it back, just to be clear, because it's going to be another judge probably by the time we do sentencing.
Well, that was one of my questions. Would I be doing it?
Maybe it is, Your Honor. Yeah, because you're taking the plea, Your Honor. We can do it that way.
I don't know. I've not been in a situation where I took a plea and was rotated out.
I think Your Honor would be the one that sentences him, but Ms. Sharpless may have better knowledge of that.
What do you say, Ms. Sharpless? Am I the sentencing judge?
Your Honor, I think unless the defendant waives Your Honor sentencing him, yes, I would think it would have to be.
Master's Touch, okay.
But there might be some complication
there's a
with
lot
whether
of
the
stuff.
court heard any evidence or not. I would need to review some.
Okay.
Yeah, why don't we just let me do it? Probably the easiest.
All right. Okay.
Don't mind.
Sir. I just added or master's touch, because he may want to ask for either or both.
Okay.
So under the terms of the agreement, sorry. So much fun. Just so you would have it. Thank you for your indulgence, Your Honor. So under the terms of the agreement, he's admitting the violation. He was previously adjudicated guilty. Defendant pleads to the bench with a 60-month cap on DOC, and that's concurrent as to all counts. There are 2 counts. With credit for all time served and no cap on supervision, defendant gives notice of his intention to request bars to bed Phoenix House or Master's Touch, and that specifically it's called the Master's Touch. I think of Pensacola, it has a fancier name. That is the agreement. He would ask to waive the pre-sentence report, Your Honor. Thank you.
State.
That's the state's agreement, Your Honor.
Mr. Brooks, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your agreement, and those terms are contained in the written agreement. And just want to make sure you've gone over this written agreement with your attorney. Make sure you understand it.
Yes, sir.
Have you gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered about the agreement?
Yes, sir.
And you believe that this is in your best interest? This is a little bit of a unique situation because it's got a cap, but it's not a firm agreement. It's not X amount, or, you understand that?
Yes, sir.
You know, so basically what I'm asking you to make sure you understand when it says pleads to the bench, what that means. Basically, you're just admitting and you're saying, you know, you're throwing yourself at the mercy of the court, but there is a cap. In other words, I can't go above that as far as the incarcerative sentence. Do you have a question about that? Go ahead.
No, sir, I just been trying to fight my crack problem, and I said one thing I was gonna do, I was gonna.
Well, don't save your arguments. I want to hear those arguments at your sentencing. Not that I'll forget them by the time you get to sentencing. So I'll have about 500 cases between. So save that for your sentencing. I want to hear all about your substance abuse and what you're trying to do and what you have done. And the state's going to be telling you all the bad things that you did, and your defense counsel is going to tell you what a great guy you are. Then we'll figure out what we're doing.
Thanks, sir.
We're going to give you, I promise you, you'll have your day in court to argue about your sentence. I'm not trying to cut you off. But it's just, this isn't the right time to do it.
Thank
you. Okay, so, but you do understand what this, how this works?
Yes, sir.
The cap, the plea to the bench with a cap?
Yes, sir.
Okay. Because you're waiving the right to go to a trial and all that stuff by doing this, okay? So this will be a final resolution except for the sentencing on this. Do you understand that?
Yes, sir.
Okay. Do you have any further questions about what we're doing here?
No, sir.
Okay. So,
does the court want us to coordinate with Your Honor's assistant
Yes.
for the setting and the sentencing hearing?
yes.
So it'll be.
We might be able to get it done before I rotate, but it'd have to be a special day. Depends on whether you guys are available, because it may be, I mean, we'll just look at it, because I do have some, particularly if you all want to do it over the holiday week or whatever, I mean.
Ideally not the week after Christmas, but.
I'm not going to, if it works for everybody, well, just call, let her know. We're not going to, we'll make sure everybody's available. We're not going to, if you've got something going on, we're not going to do it on
My assistant and Ms. Sharpless's assistants will coordinate that, Your Honor.
Okay.
That will not be a problem, whatever works.
I mean, if we can do it before the 1st, we can do it. If it has to be just after the 1st, we'll do that. I mean, I've got some availability during those.
And as long
This
as-
week and next week,
Yeah.
no.
He's ready to proceed right now, but whenever the state is ready to proceed, we'll.
I mean, do we have, this'll probably, how long do you think this'll take? Hour?
The most?
We may have time on, why don't we try and put it on the 18th? Let's, you know,
18th or 17th?
17th.
17th
Eileen will get mad at
on
me
the,
if I put it on the 18th.
on the 2:30 kind of docket, the afternoon?
No.
Do you want to do it 9 AM or late in the
We've got
morning?
another one, we've got 2 sentencings that day, don't we? We already got one.
Mr. Allen's coming
We only
back.
have 17, that's why we're doing it.
We do have some on the 18th, Your Honor, but they're in the morning, and it looks like we've already got
No,
some.
but that's specially set, and that's
It is, Your
Eileen's
Honor.
day. I don't know.
Yeah,
What do
I'm-
we have in the afternoon of the 17th?
We have a 2:30 hearing and a 3:30 hearing. And we also have felony arraignments at 1:30.
Let's try and do it in the morning, and let's see if we can, you know, if we have to come back in the afternoon or whatever.
So thank you, Your Honor. So we'll say, for now, 12/17, December 17 at 9 AM, and then we'll roll with it however it needs to be. Okay?
Okay.
All right. And it's just gonna. It's just going to be him testifying for the defense, Your Honor. Thank you. All right?
Thanks, sir.
Thank you, see you then.
Okay. Well, you'll have to wait. Your Honor, we have a person with a baby. Do you think we could deal with Miss Barber just to get the baby home? That probably explains why she got an FTA before. Could Miss
Ms. Farkas is doing some serious duty here.
Sorry.
Your Honor, Steve Medina with Haley L. Barnard, 22 CF 2083. Back November 14th, she got a no bond habeas. I think she went to jail for about a day. I had said at the time I thought she was in the advanced stages of pregnancy. In fact, she probably was, because your baby's about two weeks old.
A week and a half.
And then she, thankfully, she's here today. This is a long-running, expired probation on I think it was on a misdemeanor originally?
It was negotiated down.
Yes, it was negotiated down to a misdemeanor. Her time is expired 2 or 3 months ago, but basically the court had been given her time to repeat or complete her substance abuse evaluation treatment. The last time I talked to her back in September, she had 4 left. Do you know how many you have left?
Well, now I just talked to them last week and they said I had to start over because it's been so long.
Okay, so we can, the revolving door of substance abuse evaluation treatment with Miss Bernard. But all I can do at this point in time is ask to continue the VOP so that she would get some more time, but it's the same. You know, the state obviously wants her to complete substance abuse, as does the court. Could we have a continuance of maybe 3 months instead of 1 month or 2 months, and hopefully she can make substantial progress by.
I just have to do the 8 classes.
Yeah.
So what do you think, ma'am? How long do you need to do that? I want to give you an opportunity to complete this. Have you talked with them about
Yeah.
what you need to do? How long will it take you to do? Is it once a week?
It's 8 classes, they're $40 each.
Is it once a week?
You can go up to twice a week.
And is the issue the money?
Yeah.
Are you working at Waffle House again? Are you able to go back and work yet?
Oh, I just had a C-section
Yeah.
last week, so I could probably go back in 4 weeks.
You mean back to work at Waffle House? Yeah. So you're a single mother. It's complicated, Your Honor. Could we have a continuance until February, just to she can get it together and give a status in February. And hopefully she's made substantial progress, but I'm not warranting she'll be complete by then.
Probation, you want to have any
Your
input?
Honor, she's actually supervised by JCS.
JCS, yeah.
But she has term 9/19/2023.
Oh, okay, I have it.
So it's been quite a while
Yeah,
since
it's been
she's
a while.
terminated.
I don't think it's serves any interest of the state to have her go back to jail then.
I need to speak with Mr. Medina, we can get this resolved. So a continuance is without objection, Judge. The state's not going to seek to put the new mother in Okaloosa County Jail, so we're going to figure something out. But we do want her to get the substance abuse evaluation.
How long do we want to put it out?
I said basically February, because then by then, hopefully she's at least restarted and hopefully doesn't drop the ball.
Do we have a date in February? Is that 18th? Is that?
So we're not going a full 3 months out. We'll have some sort of accountability.
Just a couple months and just try and get started, show some proof of.
Thank you, Mr. So what's 2/10, February 10?
18.
Yes.
February 18th.
18th.
Okay, I'm
February 18th.
writing that down for you. 9 a.m., February 18th, okay?
You got the best motivation possible for you to stay clean, right?
Yeah.
Right now, you need to be thinking not about, it's not, now you don't think about yourself anymore. Now it's not just about you and getting you clean. About that little one, right?
Right.
Got to have a mama. Believe me, I spent the better part of my 18 years on the bench in dependency. And I've seen a lot of neglect, and it's all because of drug use. So take care of your baby and stay clean, okay? It's got to start right here. Even then it's hard, but right there, you can't get clean unless you want to. If you don't want to, it ain't gonna happen, okay? Good luck.
Thank
We
you.
want to try and give you a chance. The state's working with you. Let's do this.
Okay.
Take care of your child, okay?
Thank you.
Thank you.
Thank you, ma'am.
Very well behaved child. Got to be cold.
Your Honor, I think that this is his first time up on his violation of probation.
Would you announce the?
Yes, I'm sorry, Nicholas W. Brosch, B-R-O-S-C-H.
Okay, got it. Yeah, this is the first time up. I don't think there's been a.
24 CF 1377. I had been reaching out to the state to see if we could work something out for drug offense probation or community control. The state's position is guidelines, I think it's fair to say, because he does score. I think there's some special facts and circumstances. He may end up pleading to the bench, but for purposes of today, we'll deny the violation.
We'll deny and we'll come back on 121.
What is that next court date, Your Honor?
January 21st.
Thank you, Your Honor. Okay.
Thank you.
Thank you, Your Honor.
Mr. Medina, before we do the sentencing, Perez, you have a couple other cases that are on my docket that.
Yes, Judge Adams.
Adams is
Frank,
one.
He's it's a incompetent client who's under court-ordered outpatient restoration. The court is aware that there's been some delays in getting outpatient restoration completed for many of my clients. I do represent that my assistant has told me that he is in the hospital today, so he is not physically able to come. I hope that we can.
So do we need to continue it in order to try and get the restoration? How far out do you want? Do you just go to January or go out to February?
I'd rather go to February.
Okay, so we'll continue this matter for another status in 2/18, February 18th.
Thank you, Your Honor.
And that'll be in the morning. Let me see, I think I saw one other one. Nope, let's see here.
And the forensic officer is aware of Mr. Adams, so hopefully we'll be able to work on his case in the end.
Okay, those are all the ones I have other than Valerie Perez.
That's correct, Judge. We've been speaking to the evaluators that replaced Mr. Barnes, and she's aware of this, of Mr. Adams.
Mhm.
He's on our list of people to seek once she has her qualification.
Is there a William Davis on your docket, Judge?
Is there a what?
William Davis. I have that on the AM.
Who's the attorney?
I thought it would have been Mr. Medina. Do you have D?
Sir?
D, the letter D.
No, that's me.
That's Farkas.
Davis?
I don't have a Davis
I don't either. I mean, I have a client, but what's the first?
William.
on this docket.
Well, we
I'm
already
not
appeared
that I
on
have.
William Davis earlier, we continued it
Okay.
Does
to January 21st.
Does the court or Miss Godfrey, did we have Donnie Bray on the docket? B-R-A-Y?
Is that one of yours?
It is one of mine. I just didn't know if he was on the docket because I know he's in Walton County
No.
Jail. Okay.
Not on my docket.
Okay.
Of course, my docket isn't always right. Clerk's docket is the docket.
I have Mr. Bray set for December 17th.
I don't think he heard you.
I just wanted you to know that that would be, the call.
The 17th or the 18th?
17th.
Mr. Medina, Mr. Bray is the 17th of December.
Oh, okay, so he's coming up next week. Okay.
Yeah.
He probably will still be in Walton County Jail then, but we'll find out. Thank you. He got admitted to inpatient treatment. I'm not sure which place. I think Keaton or Phoenix House, and we'll work something out if he's not here.
Okay. So, we want to proceed with Perez.
Yes, Your Honor. Could Valerie S. Perez come before the court in 21 CF 2912, 20 CF 1286, and 18 CF 2796?
Forgive me, Judge, may I be excused?
You may.
Thank you.
And
Mr.
Your Honor,
Medina.
Ms. Perez, since she was before the court for her sentencing hearing, I think your sentencing was actually on October 7, and then the court basically took matters under advisement to see if she could be accepted at Phoenix House on November 14. By then, she hadn't been accepted yet, but now she is accepted at Phoenix House residential program, and the defendant is requesting to be sentenced to the Phoenix House residential program, and that it be pursuant to a 36-month drug offender probation, reinstatement and modification of her supervision. I do need to clarify on the supervision that everything's always got to be complicated, especially in an older, complex situation. But basically, the case where she has some remaining time is 21 CF 2912. She has two felony VOP counts in 21 CF 2912, each of which would allow an additional 2 years of supervision. So we could do a 36-month drug offender probation sentence. It would need to be on one of the counts be for 24 months drug offender probation, followed by 12 months in the other count of drug offender probation. So for a total of 36 months.
Okay.
The court actually has 48 months of leeway, but I just wanted the court to know it would be a legal sentence, but we have to stack it consecutively, 24 followed by 12. And I think that would be our request. I don't think there are any other provisions other than we are specifically requesting, because she's in compliance, she's reporting in Escambia County, we ask that it be street to bed. She's going to have to maintain careful communications with Phoenix House and with Escambia County Probation to make sure that she, as soon as a bed is available, is transported. She is going to, her fiance, they're going to provide the transportation. So basically, if they say a bed's available, I think it would need to be that she would report within 24 hours of getting the call that the bed was available, and she would report at the Phoenix House facility in Marion County, Your Honor.
Is that where the Phoenix House facility is?
It's Citra and near Ocala in Marion County, Your Honor.
I don't think I ever knew that.
I do, just to always, everything's always got to be complicated, but Ms. Perez told me that Phoenix House is kind of under some scrutiny, and it's always possible that the state will yank a contract or whatever, but I don't control that. The court doesn't control that. We're certainly hoping she can go to Phoenix House as soon as the bed becomes available. Then that would be our request.
Ms. Sharpless.
Your Honor, the state just reiterates the arguments that were made at the prior sentencing hearing, believes that Ms. Perez should be sentenced to her guideline score sheet since she has been.
Which is like 31.06 or something like that?
Yes, I think so, Your Honor.
Yeah, it was a 36-month suspended sentence.
Yes, just because, Your Honor, that she has already been to Keaton and completed Keaton. Again, the sentencing is at the discretion of the court. So the state, again, would just reiterate the prior arguments made, and the sentencing is at the discretion of the court.
And can I say, I apologize, but Ms. Sharpless reminded me of something. Because of the 36-month suspended sentence, that does ultimately cap the probation too. So I don't know if Ms. Perez has any of these details, but I know that we could have it be a 24-month probation. I think it could be 36 months drug offender probation, but I misstated, it cannot be 48 months because it would be capped by the 36 months suspended sentence would apply to probation too.
There is already a 36-month suspended sentence?
Yes.
And Your Honor, going forward, the state would ask that that be removed from the court's order going forward if the court is to send her to Phoenix House. But right now, yes, there is a 36-month suspended sentence. Again, as we've had come up in other cases, yes, that does include probation.
What do you mean it includes probation?
The 36 months would be if
The maximum
Yes.
sentence, whether it's probation
or Department of Corrections or a combination thereof, the maximum sentence would be 36 months. Unless it's specifically stated that there's no cap on incarceration, which I don't think was in the prior plea agreement.
I think the prior sentences have made it clear it was a 36-month suspended sentence. I think that does cap.
So, Ms. Perez?
Yes, sir.
You've already been to Keaton, successful with Keaton. You've already been through this, out of suspended sentence. Why should I send you to Phoenix House again?
Because it's been 3 years and I've completed everything I'm supposed to do.
Been 3 years since what?
Since I went to Phoenix, or Keaton. I did everything, met all my stipulations for my probation, and this wouldn't have happened if I wouldn't have went into psychosis like I did from that medication that I was on. I was doing so good, like I worked, everything was fine, everything was great. I literally was about to get off in 5 months after doing everything I was supposed to after Keaton. It's been 3 years since I graduated Keaton, and I've been living a perfectly regular, good life and doing everything I'm supposed to do right, just waiting on my time to get done. And then when I went into psychosis is why all of this happened anyways, because I went and it was the medication. I would not have not violated or did anything like that because I was doing great for over 3 years straight. And I don't do anything wrong, like I've changed my life completely since all of that happened. And even though when I got out of the psychosis and got back to normal, I've continued on with my regular life and to live normally and not do anything wrong. And I just don't want to get sent away to prison because of something that was like, I was not in the right state of mind, like I wasn't there. And it's not something that's going to happen again.
No, that's good. Court's going to order 36 months drug offender probation with the condition, specific condition that as soon as there's an available bed for the defendant to, go to Phoenix House and complete their program. Any aftercare they have on top of it. So it's been a long road, you know. It's not where you start, it's where you end. We're going to see if we can get this, have a good ending. Okay.
Thank you so much.
And just for the record, Your Honor, it would be 24 months on one of her VOP charges, and then in the other VOP charge, it would be a consecutive 12 months. That way,
however structurally you have to do it, I'm going to let the lawyers work that out to make sure that it meets the. I'm going to let the lawyers work out the details of the order to make sure that we can get it in. I understand the issue, the maximum.
I think basically probation had already expired in 20 CF 1286 and 18 CF 2796. The only case that there was active probation was 21 CF 2912, so the sentence would be imposed in 21 CF 2912 only.
And the other ones are termed?
They terminated by expiration.
And Your Honor, I do think that when we were speaking with probation earlier, since this is not bars to bed, is in the court's order that when she gets a call to go to Phoenix House, she's to let her probation officer know that's where she's going, because probation is not going to get a call from Phoenix House that a bed is available, and they've called her.
Yeah, I don't have a problem with that. I mean, whatever's the proper procedure on it.
Officer Womack and I stay in contact weekly, so I'll let him know. We talk often.
Is this your boyfriend back there?
That's my fiance back there.
Fiance, okay.
Yes, sir.
You all have some responsibility. You all can either support one another or drag each other down. You know, it's always usually the least common denominator. Usually it doesn't help. So you guys need to be easy with one another and really work hard to do this. It's not easy.
And are we removing the suspended sentence?
May I ask a question? Because Ms. Sharpless is inquiring, does the clerk show that we did produce a score sheet at sentencing? I think we did provide it to the court at sentencing, but I don't have a copy.
I do not have a copy.
Okay, Your Honor, I will, since me and Mr. Medina are gonna be here this afternoon, I'll get the score sheet to the court this afternoon.
Thank you.
The court's not removing the suspended sentence at this point. Can I just leave it there?
I
How does
think
that work?
That's the court, that's up to the court. If the court wants to continue to impose a 36-month suspended sentence.
I just wanted to be frank.
Because it's already on, I'm not adding it.
I want to be candid with the court, as an officer of the court, is that Ms. Sharpless is raising a valid concern, because basically because there's 36 months suspended sentence, the court could still impose that suspended sentence, is the position of the state. I'm just concerned that
The only thing we can do is just raise it, and then, there'll be minimum guidelines if she violates, right? There's gonna be an she'll be looking down the barrel of an incarcerative sentence if he violates. So whether it's 36-month guarantee,
So, Your Honor, the reason the state asked for that whenever people have prior suspended sentences is that she's going to score more than 36 months if she has a violation.
that's true.
That's why the state asked for that.
Okay.
She was did you hear that, ma'am? The state is doing you a favor.
Yes, they're capping it, so that way I can't get more.
So, do I just leave it?
So
Can I do
The
that?
state was asking for it to be removed, but it's up to the court
Oh,
whether
I
it's
see.
removed or whether that continues to be in the court's order.
So that would remain, the 36-month suspended sentence would
Okay.
remain hanging over her head were she to violate. And this is a reinstatement and modification rather than a revocation, therefore the court would have that leeway.
Okay, very good.
Because I'd be going to prison anyway if I violated. Right?
What's that?
I said I'd be going to prison anyway if I violated, so.
That's right.
Well, technically, you always have the right to a hearing, but you burn a lot of bridges at this point.
Like, this is the last straw. Like, this is it. Yeah, so.
Thank you.
Ma'am, we want you to be successful. We don't want you to be thinking about the other thing.
Yes, sir, no, I'm not going to violate at all. I feel like this wouldn't have happened.
If it's a motivation to help you, though, a little bit more, that's good.
Scary. Yeah, definitely.